In the last section, we explored how a deed of trust functions as a security instrument and how a deed of reconveyance is recorded once a loan is paid in full to return full ownership to the borrower. Once a property is free of liens and encumbrances, ownership can be conveyed to another party through a legal instrument known as a deed. Deeds are among the most essential documents in real estate because they serve as written evidence of title transfer and outline the rights, protections, and warranties conveyed from one party to another. A deed is a legal document that transfers ownership or an interest in real property from one party, the grantor, to another, the grantee. Under ARS, paragraph 33401 through paragraph 33420, all conveyances of real property in Arizona must be in writing, signed by the grantor, and properly acknowledged before a notary public to be valid and recordable. Each type of deed carries different levels of assurance regarding the title's quality and freedom from encumbrances. Understanding these differences is critical to protecting both buyers and sellers during real estate transactions. General Warranty Deed. A general warranty deed provides the highest level of protection for the grantee because the grantor guarantees that the property title is free of defects, whether they arose before or during the grantor's ownership. The grantor warrants that they hold clear title and will defend the grantee against any future claims to the property. For example, if Mark sells his home to Olivia using a general warranty deed and a prior lien surfaces from a previous owner, Mark is legally obligated to defend Olivia's ownership and resolve the claim. This deed type includes covenants of cession, right to convey, freedom from encumbrances, quiet enjoyment, warranty forever, and further assurances. Because of these comprehensive protections, general warranty deeds are most commonly used in traditional residential transactions, where the buyer expects clear, marketable title. Special Warranty Deed. A special warranty deed offers a more limited guarantee. The grantor warrants only that the property was not encumbered during their period of ownership, but makes no promises about defects that may have existed before they took title. This type of deed is common in commercial transactions, foreclosures, and sales involving corporations or trusts. For example, if a bank sells a foreclosed property to a buyer, it will typically use a special warranty deed, promising only that the bank itself did nothing to impair title while it owned the property. If an earlier lien or defect exists, the buyer bears the risk. This limitation is why title insurance is vital when purchasing property conveyed by special warranty deed. Bargain and sale deed. A bargain and sale deed implies that the grantor holds title and has the right to convey it, but it includes no warranties or guarantees against liens or encumbrances. This deed simply transfers whatever interest the grantor has in the property without promising that title is free and clear. Bargain and sale deeds are often used in tax sales, sheriff's deeds, or sales by executors and administrators in probate proceedings. For instance, if an estate executor conveys property through a bargain and sale deed, the buyer accepts the property as is regarding title condition. While this deed may transfer ownership, it offers no recourse if a title issue is later discovered. Quitclaim deed. A quitclaim deed provides the least protection to the grantee. It conveys only whatever interest the grantor currently has in the property, if any, and makes no warranties or guarantees of title. If the grantor has no ownership interest, the grantee receives nothing. Quitclaim deeds are most commonly used to clear title defects, transfer property between family members, or resolve disputes. For example, if two siblings inherit property and one wishes to release their claim to the other, a quitclaim deed can be used. Similarly, a spouse can use a quitclaim deed to remove their name from property ownership following a divorce. Because it carries no guarantees, a quitclaim deed is never advisable in an arm's-length sale between unrelated buyers and sellers. Beneficiary deed. A beneficiary deed, authorized by ARS, paragraph 33405, allows an owner to designate one or more beneficiaries to automatically inherit the property upon the owner's death without going through probate. The owner retains full ownership and control during their lifetime and can revoke or change the deed at any time. For instance, if Linda records a beneficiary deed naming her daughter, Emily, as beneficiary, ownership automatically transfers to Emily upon Linda's death. This transfer bypasses probate, saving time and expense. Beneficiary deeds are a useful estate planning tool, but must be recorded before the owner's death to be valid. Disclaimer deed. A disclaimer deed is unique to community property states like Arizona. It is used when one spouse wants to disclaim any ownership interest in property acquired by the other spouse, typically when the property is purchased as sole and separate. The disclaimer deed ensures the property is not considered community property and prevents the non-owning spouse from making future claims. For example, if John purchases a home after marriage and wishes to keep it as his separate property, his spouse, Megan, would sign a disclaimer deed affirming that she has no interest in the property. This document protects John's sole ownership and is often required by title companies before issuing clear title. Comparison of deed protections. Each deed type offers varying levels of protection. General warranty deed, full protection against all title defects. Special warranty deed, limited protection, covers only grantor's period of ownership. Bargain and sale deed, implies ownership but offers no warranties. Quitclaim deed, transfers whatever interest exists with no guarantees. Beneficiary deed, transfers title upon death without probate. Disclaimer deed, used to confirm non-ownership by a spouse in a community property state. Case example, Watson Construction, Kobe RV, AmFac Mortgage Corp., 1979. In this Arizona case, the court highlighted the distinctions between deed types, emphasizing that a warranty deed carries enforceable covenants that run with the land, while a quitclaim deed conveys only the interest held by the grantor. The decision reinforced the principle that the type of deed determines the extent of protection available to future owners. Discussion. Why does a general warranty deed provide the highest level of protection to a buyer? Answer. Because the grantor guarantees that the title is free from all defects, both during and before their ownership, and agrees to defend against any claims. When might a special warranty deed be more appropriate than a general warranty deed? Answer. In transactions such as foreclosures or corporate property transfers, where the seller only wants to warrant against defects occurring during their ownership. What is the main purpose of a disclaimer deed in Arizona? Answer. To confirm that one spouse has no ownership interest in property acquired as the other spouse's sole and separate property. Review. Summary deeds are the legal foundation of property transfer in Arizona, each serving a specific purpose and offering different levels of title protection. A general warranty deed offers the most comprehensive assurances, while a quitclaim deed offers none. Between these extremes lie special warranty deeds, bargain and sale deeds, beneficiary deeds, and disclaimer deeds, each tailored to unique legal or personal circumstances. Under ARS, paragraph 33-401 through paragraph 33-420, deeds must be in writing, signed, and recorded to provide public notice. Selecting the appropriate deed type is essential to ensuring both parties' rights are protected and that ownership transfers in accordance with Arizona law.